Domestic violence, dowry harassment, live-in relationships, and soft porn. A judgment delivered by the Allahabad High Court on Monday had all of this. The court in fact went on to issue guidelines to protect husbands and their families in dowry cases as well. But the Supreme Court had overruled similar guidelines 4 years ago. In this video, I will explain what this case before the Allahabad High Court was about, what the court has now said, and what the Supreme Court had earlier said on this. So now in this case, we have the wife Shivangi Bansal who got married to Sahib Bansal on a chilly December 2015 day. But things seem to have gone downhill soon after. Shivangi alleged that her in-laws kept demanding an additional dowry of 50 lakhs from her and that her husband kept abusing her sexually and physically. Her FIR filed in October 2018 detailed several of these instances. She alleged that he tried to have anal sex with her and also shoved her head in the toilet commode. The FIR also claimed that the father-in-law and brother-in-law asked her for sexual favors and her husband's family forced her to have an abortion as well. So this FIR was filed in October 2018. Now the accused in the FIR were her husband and a few relatives. Now the police also filed a charge sheet in this case. Among other things, the charge sheet mentioned section 498A of the Indian Penal Code, which is also called the anti-dowry law, and it criminalizes subjecting a woman to cruelty. This could be by the husband or his relatives. The charge sheet also mentioned Section 307 of the Indian Penal Code, which is attempt to murder. It also mentioned provisions of the Protection of Women from Domestic Violence Act 2005. And then the husband and his parents went to the court asking that they should be discharged from the case, basically saying that they shouldn't be asked to go to trial and should be let off. Now, the lower court refused this, which is when they came to the High Court. And now in his judgment, Justice Rahul Chaturvedi blamed this law, Section 498 instead, for adversely affecting our social fibre, especially in northern India. These were his words. The judge said a lot of things about how this law affects the institution of marriage and how couples are now getting into live-in relationships to be, and I quote, free from its legal implications, commitment and responsibilities, basically legal implications of a marriage. The court then took another step ahead and issued guidelines to prevent misuse of Section 498A, saying, and I quote again, keeping in view the growing tendency in the masses to nail the husband and all family members by a general and sweeping allegations. These were the court's words. So it basically ordered that after an FIR is registered under Section 498A, no arrest or coercive action can be taken against the husband or his family members during a cooling off period of 2 months. During these 2 months, the matter needs to be referred to the Family Welfare Committee in each district. The court also laid down the composition of these committees and its powers and duties. It said that the committee should include a senior-most fifth-year student of a government law college or state university or national law university who has a good academic track record and is a public-spirited young man. These panels could also include educated wives of senior judicial or administrative officers of the district, among others. So there were other people also who would be included. It also laid down the procedure to be followed in the 2-month cooling off period in case an FIR is registered under 498A and the role that the committee will play in this. So the bench said that the contesting parties, the husband and wife, would need to appear before the committee along with a maximum of 4 elderly persons and have a serious deliberation between them. The committee would then prepare a vivid report. Meanwhile, the police are also expected to have a peripheral investigation into the matter. And the court said that when a settlement is reached between the parties, it would be open for the district and sessions judge or other senior judicial officers that this judge might nominate to dispose of the proceedings, or they could even close the criminal case. However, just to let you know, as I mentioned, the Supreme Court had issued similar guidelines back in 2017 to prevent misuse of Section 498A. In fact, these guidelines were extremely similar. It had directed that even every district will have these 3-member committees. Any complaint made under Section 498A would be referred to and looked into by these committees. They were supposed to interact with the parties and submit a report within 1 month. Until this happens, nobody would be arrested. That's what Supreme Court had said in 2017. If the parties reached a conclusion during this time, Supreme Court had said that then it would be open for the district and sessions judge to dispose of the proceedings and close the criminal case. So it's very similar to the Allahabad High Court judgment. But a year after this, in September 2018, a 3-judge bench partially modified this ruling. It had observed that the earlier directions on forming these family welfare committees are impermissible. So basically it said that formation of these committees and their duties are beyond the scope of the law, and these directions don't flow out of any provision. There's no provision that says that. And so the court could not have issued these directions. So in simpler words, the Supreme Court in 2018 basically overruled the earlier directions related to these committees as well as on the settlement. The court said that if the parties do reach a settlement, they can file a petition in the High Court. Therefore, the Supreme Court has in the past overruled very similar directions, similar to, as I said, what the High Court had now said. There's another thing that I want to highlight here. The High Court also made certain remarks on the language used in the FIR, recounting the allegations made by the woman. In the judgment, the judge said that and I quote, "the graphic and vivid descriptions of the incident without any shame or hitch of any sort," unquote, speaks volumes about the woman's mental condition and about the venom in her mind. These were the court's words. The court, in fact, took severe objection to this language, observing that, and I quote again, "the graphical description portrayed by her in her FIR is deplorable, to be condemned in strongest terms," unquote. So it said that it wanted to simply overlook these graphical and distressing allegations. The judge also said that the language of the FIR should be decent and no amount of atrocities faced by the informant, that is the woman, could justify her to use such type of expressions. And it also said that even soft and decent expressions would well communicate the alleged atrocities faced by her. Now, if you're wondering what happened to the husband and his parents in this case, the court basically discharged the parents. It even dismissed the allegations that the father-in-law asked for sexual favors from the woman, from Shivangi, saying that in our traditional Indian family where they are residing in a joint family with an unmarried son, it is highly improbable and difficult to digest the allegations that the father-in-law or the brother-in-law demanded sexual favors, but the court has asked the husband to stand trial in the case. So basically the case will proceed against him. That's all I have for you for now. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.